Good morning, all. We ready? May we proceed?
Good morning, Chair.
Yeah, we may proceed then, yes. Just to remind the witness, sir, you are still under oath and under cross-examination. Yes?
Thank you, Chair. Good morning, Mr. Mukhasho.
Good morning, everyone.
Yesterday we ended at page 258, volume 8. I'd like today to start at page 257 of volume 8. And you know by now that that's the first page of the report which Mr. Baltak prepared at the request of the chair via Mr. Dingizwayo and Ms. Ngoye. Can you please focus at the second paragraph? Sorry, let's start with the first. This report has been requested by the chairperson of PRASA's interim board advocate, T.A.N. Makhubele. Siaya Consulting Engineers have been appointed by PRASA as technical advisor and supervision for Gauteng 1 resignaling project, Gauteng 2 resignaling project, and radio digital railway signaling network project, known as GSMR project. Makensa Mabunda was in leading Siaya. I take it that all of these characters...
But confirm that, yes, he was present at the commission on the 28th of August.
At the beginning... at the beginning of the inquiry, the legal representation of Siaya, SLR, gave an introduction and stated that they want only to establish facts in a transparent way. Do you see that?
I see that, yes.
So that according to Mr. Baltak, there was nothing to be concealed at that hearing. I don't know whether your instructions were different in relation to how the proceedings of the hearing had to be conducted so far as the discovery of the truth was concerned.
I did not have any instructions different from that.
Yes. You recall, and I'm sure by now you have read the transcript of the proceedings in volume 16.1.
You might want to take me through the transcript. I did not find sufficient time to go through, through all of it.
I can. I'm going to interrupt myself, Chair. For the present purposes, can I ask you to go to volume 16.1, page 257?
I'm on it, Chair.
Somewhere down the middle, I suppose it will be around line 12. You'll see that the commissioner says to Mr. Buotes, "What is on the record? Just summarize that, counsel, please." Do you see that?
I see that line, yes.
257, Judge Mushidi, it's around line 12 or 13 from the top. You will see that more or less along that line, the Commissioner invites Mr. Botha, says, what is on the record? Just summarize that, counsel, please. Do you see that, Mr. Mukhasha?
I see that, Chair, yes.
And the response by Mr. Botha is as follows. What I have submitted to you before Advocate Tsatsawane entered into the room is that I have invited Advocate Tsatsawane together with his instructing attorney to be present when the evidence that I am about to introduce is laid. The reason being, and I have also informed Advocate Tsatsawane prior during more than one telephonic discussion we had, is that this is not a Spanish Inquisition. It is not a witch hunt. The purpose of this inquiry is to establish the truth relating to the relationship between the relevant parties, and I have no objection if either Advocate Tsatsawane or his instructing attorney or representatives of his instructing attorney are present. The rest speaks for itself. But the point for now is that it was evident to you being present in the inquiry that its purpose, at least as far as Mr. Botha is concerned, was to discover the truth, correct?
I agree with that, yes.
We'll come back to this transcript later on. I just wanted to establish the fact that all who attended knew at the point in time that the purpose of the inquiry was to discover the truth. That was, by way of interruption, when I was reading out to you the report of Mr. Botha at volume 8, page 257. Are you there?
The report of Mr. Baltek, rather.
Baltek, my apologies. Are you back at volume 8, page 257?
Correct, I am, Chair.
Then he continues after telling us about the transparency. In essence, I have been asked by the Commissioner to answer to the following 3 questions regarding re-signaling projects. 1, did Siaya fulfill their contractual obligations? 2, have Siaya been remunerated for the work done? 3, if there is any payment outstanding towards Siaya, SL produced a list of Siaya unpaid invoices. Those were the 3 questions identified by Mr. Baltek in this report. And I assume from the reading of the transcript, Mr. Baltek correctly reflect what he was asked to do at the inquiry. Do you take issue with that part of his report?
I accept that.
Yes. And then he says, my answers to these 3 questions. To the first question, yes, in my opinion, Siaya fulfilled their obligations before entering into liquidation. Do you see that?
I see that, yes.
In answer to the second question, 2, I was aware that there were instances when Siaya have not been paid for the work done. In answer to the third question, 3, I needed to look at in the file and to consult with my colleagues, Johan Edwards, Chief Engineer, Signal, in order to come up with a reliable response. Again, do you take issue with that part of Mr. Baltek's report?
I take note of what he says and I accept the contents of what he says.
Yes. And I take it that you accept that that's the truth that he was called upon at the inquiry to talk to, and he did talk to that truth.
I accept that.
Lest there be doubt on the correctness of this report, I now would like to take you to the transcript. I will focus for now, Chair, on the evidence given by Mr. Baltak, and I won't take you through the rest of the other evidence given by other witnesses, because the transcript speaks for itself on that score, and we will make submissions thereafter. But in the interest of time and transparency, I would like to use the example of Mr. Baltak, unless you have any other suggestion to the contrary.
I think, Chair, the transcript is what it is, and I don't have a problem being taken through what went on with Mr. Baltak or any other witness from PRASA. I agree with your approach.
Okay. And we can take a shortcut if you so prefer. And I invited you to look at the transcript overnight. My proposition to you ultimately is that what is recorded in the transcript is the truth as far as the witnesses who testified are concerned. Would you take issue with that proposition?
I accept that the transcript, and I tried to go through it, or all of it, but it was not possible. I accept that the contents of the transcript would be a true recordal of what went on during the proceedings. I don't think I can comment any further than that.
Thank you. And we will ultimately submit, and if you want to comment, we will submit to the tribunal that the evidence of the witnesses as recorded in the transcript reflect major concessions on process liability to the Sihaya group of companies.
Perhaps to the extent of the evidence they were required to give. Just to assist, I did mention yesterday that there were reports or some submissions we made post the proceedings themselves. I do not know how you wish that I deal with the documents I have found, which may give you some indication regarding our position as the legal team, regarding all of the processes that were concerned with the commission itself, and that which we were expected to do to assist the commission further. There were four attachments that were part of Madame Ngoye's affidavit, which I spoke on in my own affidavit for the State Capture Commission. I was a bit concerned yesterday when I couldn't find the documents in the papers, but I've managed to.
Opportunity later on to look at them, and if the issues are rising, then we will have to deal with them. But for my part, I don't want to be seen to be suppressing information or evidence.
Well, then let's just then deal with the question that you put to him.
Yes.
Would you put it to him again, and let's see what his answer is. He's got documents that he says he has that may assist him in answering your question.
Yes.
So let's hear the question again, and let's see what the answer is.
Thank you, Chair. Mr. Mokhasho, I repeat that from the reading of the transcript, which I suggested you do overnight, it is clear that witnesses who testified made major concessions on process liability to the Sihaya group of companies who had contracts with it, including Sihaya DB in liquidation and Sihaya Rail. Do you take issue with that proposition?
I think in my response, I did indicate that I accept that the transcript is a true recordal of the submissions made by witnesses, I might have a different answer if you ask me whether I accept that the evidence led by the witnesses, whether the employees of PRASA at the time or not, amount to what you refer to as major concessions. I might have a different view. And that view is well articulated in the responses or the letters that I referred to yesterday, which regrettably I couldn't locate, but which letters I have now.
Well,
So I'm not, oh yes.
well, let's just, you seem to look at the question in two ways. What the witnesses said at the commission and what your view is as to what was said. My understanding of the question is this. You agree that what the record says is what the witnesses said at the commission. Is that right?
My answer to that is yes.
As to the content of what they said, whether that is true or not, as far as you are concerned, you have a different view. Would I be correct?
That's correct.
And to substantiate the latter part of that answer, you say you have documents that back up your stance. Is that correct?
That's correct.
Yes, I think we have it. Thank you.
Chair, I have not seen the letters, and I will get to them as soon as they're made available to me.
Yes, you should have seen the letters. Do you want us to stand down? Do you like to have the lookers now, or do you want to deal with it later?
Not for my purposes.
Yes, thank
Yes.
you.
Mr.
Then
Makhasha, I mean, let's be clear on this. You're a lawyer, and some of us are lawyers too. You did not consult with Mr. Baltic when you formulated the pleas, correct?
That's correct.
The first time you hear what Mr. Baltic has to say as a witness is when he testified at the inquiry, correct?
That's correct.
Yes. And you have no doubt about what he said in that regard?
I don't dispute that, yes.
Yes. I have taken you to page 257 and 258 of volume
16.
volume 8.
Oh, yes, I'm on it.
And by his own admission, Mr. Baltic accepts that PRASA is liable to Siaya in that report.
I accept that that is what he said.
Yes. You are a representative and not a witness. So you'll be guided by what a witness says in relation to a dispute on which he or she testifies.
That's correct.
Yes. What has led us to this is page 76 of volume 19. Can you go back to page 76 of volume 19?
All right, I've got the bundle. I'm going to do that now. Page 76. I'm on page 76, Chair.
Remember, I interrupted myself when I had asked you to consider what Mr. Botha said in that email to you on the 6th of September 2017. And he was summarizing for you what Mr. Baltic had said at the inquiry. In the last paragraph of page 76, and I read it out to you, I'm not going to read it out again, but if you turn over to page 77, you will see that after that summary, Mr. Botha had posed a question to you. Does your client persist in pursuing the arbitration under these circumstances, question mark? Remember, that's what interrupted me to take you to these other files. And I had wanted to establish from you what was your response to that question as a colleague of Mr. Botha's.
Okay. With your permission, Chair, I'm going to simply read out what the response was. And I think one would have to accept that I did not owe any duty to Mr. Botha in as far as the conduct of the matters may be concerned. My responsibility is to take the information that becomes available to me as an attorney to my clients for instructions. And we have had to deal with what Mr. Botha raised in his email to me, not because he raised this email to me, but because we were instructed at the commission to assist the commission further by assisting PRASA witnesses in gathering the relevant information that was required of them. Part of what we have had to do was to consult with Mr. Baltek, as similarly others, which we did, and help them formulate their own submissions to Mr. Mackenzie. So I've got an email here, and I see that Mr. Botha, if I may go back, refers to a case number 47597 of 2015, but I suppose it should read 2016. And if we are on the same page regarding that, this is what we said in our letter dated the 6th of September to Mr. Mackenzie. And as I say, this was not in response to Mr. Botha's long email to me. It was in response to some of the responsibilities we had towards the commission. If I'm allowed to go into it, we say, and it's addressed to both the commissioners and Mr. Mackenzie. Attention, Mr. Mabunda. It's a CIA Consulting Engineering in liquidation that is the subject. We refer to the case number 47597 of 2016. Subject matter, GSMR agreement. Parties, CIA Rail Solutions. And I think you must perhaps pay attention to that the party here, or the company in whose respect this debate ensues, is CIA Rail. We say we act on the instructions of PRASA and also refer to the Commission's proceedings of the 28th of August 2017, in which, or to which Mr. Baltek was served with a subpoena to attend to testify as a witness. Our paragraph 2 says, Mr. Baltek, in respect of whom we also act, attended the Commission on the aforesaid date and was requested to calculate, by also engaging with Mr. Mabunda, what the value of the GSMR variation order should be. In response to the Commission's request, it is our client's instructions that the purported agreement was between CIA Rail Solutions, which was registered on the 30th of June 2009, with the company registration number 2009/012646 of 07, and not CIA Consulting Engineers, which latter company is under liquidation. Our next paragraph says, our clients have not been served with any documents that suggest that CIA Rail Solutions is under liquidation, either on its own or jointly with CIA Consulting Engineers. Our next paragraph says, accordingly, CIA Rail Solutions Limited is not and ought not to be part of the proceedings with which the Commission may be concerned with. If I turn the page over, we are saying to Mr. Mackenzie and the commissioners, consequently, it is our client, it is our position that our client, or it is not clear to our client, nor certain as to why Mr. Baltek has been subpoenaed to come and be of assistance to the Commission in liquidation proceedings of CIA Consulting Engineers when the GSMR project has no links with the company, which is the subject of the current liquidation proceedings. In the circumstances, we request that you, alternatively the Commission, assist our clients further by responding to the submissions we make in paragraph supra. We hope to hear from you soon. This is the response. It's in response to the Commission's request that we assist our clients in formulating further submissions when they engage further with Mr. Mabunda. And to my belief, Mr. Mabunda represented the CIA group of companies. Thank you, Chair.
I've not seen the letter, but just help me. What is the date of the letter?
The letter is dated the 6th of September 2017. Which means a couple of days after the actual hearings.
Yes. And you say you addressed this letter to the commissioner?
It's addressed to Mr. Mackenzie in the main, but because it was a request by the commission or the commissioners, we copied Isaac of Tshwane Trust and we copied Krichen of Krichen Consult.
Yes.
And I believe these two were commissioners.
Yes. And you confirm that that was not in response to Mr. Botha's email?
Certainly not.
Yes, thank you. And you say that what you said in that letter was upon instructions by your client?
Correct.
Specifically, who in PRASA gave you the instructions to respond the way you did?
It will be Ms. Mukotedi and Mr. Dingizwayo.
Now, I'm afraid I'm going to ask you to go back to page 258.
Of which bundle? Bundle 8.
Volume 8, yes.
I'm on to page 258, Chair.
And if you don't mind, would you make a copy of your letter available to us during the tea time to have a look at it?
I have already.
Thank you. You'll see when you are at page 258, Mr. Baltek concluded his report to the chairperson as follows. And I'm at the last paragraph of Mr. Baltek's report. After the testimony, PRASA Legal Department has instructed me not to enter in any discussion with Mackenzie Mabunda, or to Mr. Baltek not to engage with Mr. Mabunda and the commissioner. And his answer was twofold, and I'd like to deal with the first part of it first. He said that he did not give those instructions to Mr. Baltek. And you say that you got instructions to tell Mr. Mabunda that Mr. Baltek must not engage with him upon the instructions of Mr. Dingizwayo and Ms. Mukotedi. I take it that you did not hear that part of Mr. Dingizwayo's evidence. But if he said that to the chair of the tribunal and his colleagues, he would not be telling the truth as far as you are concerned.
I'm not sure I can say that the letter I have just read out, it may be about perhaps the same issues, about the same cases, but I'm not sure if out of reading this letter one can conclude that the instruction by whoever it is at PRASA to Mr. Baltek that he must not talk to the commissioners, whether at that point or any longer, would have been an instruction from Mr. Dingizwayo. I'm not sure I can say that.
No. What Mr. Baltek records here is an instruction from legal department not to engage with Mr. Mabunda, correct?
I accept that that's what he says here.
And that's the same point in different ways your letter repeats to Mr. Mabunda, correct?
I will agree with that assertion.
Yes.
Yes.
We're talking about the same subject, talking to the same point
Yes.
from different perspective. And the simple point that I'm asking you is this. If Mr. Dingizoyo gave instructions to make that point to Mr. Mabunda, and here in these proceedings, he denied that he never gave instructions, he would not be telling the truth as far as you are concerned.
You asking for my opinion on that?
Yes.
I think I will take you back to what I said earlier. I do not know, I'm not aware about the circumstances under which the instruction was given, but to the extent that you would want to say, our letter to the Commissioner and Mr. Mabunda somewhat said to both of them that the matter is not a subject and shouldn't be a subject of the liquidations proceedings. I would somewhat agree with your assertion that then it meant that PRASA had no business engaging with the commissioners on that matter any further. That I would agree with. I can't comment on whether what he said amounted to a lie or not.
That's fine. The record will speak for itself, and we will take up the issue in argument. But for now, let me put the second part of Mr. Dingizoya's testimony on the question of instructions to Mr. Baltek. He said, if there is anyone in the legal department who had given the type of instruction described by Mr. Baltek on 258, volume 8, that would be unlawful. That's what he said to this tribunal. You may not have knowledge of what he said. But if he said that, and he gave you a similar instruction to convey to Mr. Mabunda, that, in your knowledge, would not be unlawful, because he gave you that instruction to convey to Mr. Mabunda.
Indeed, I received instructions from Mr. Dingizoyo and Ms. Mukoteri.
And if he told the tribunal that that type of instruction would be unlawful, but he gave it to you, and you executed that instruction, in your view, he would be wrong in that regard, correct?
As I say, I'm not privy to the circumstances that led to Mr. Baltek making this submission, as appears on page 258, and unfortunately I cannot speak for Mr. Dingizoyo. I'm uncomfortable to be expected to do that.
Are you at page 77, volume 19?
Yes, I've just pulled it, Chair.
In the second unnumbered paragraph of page 77, volume 19, Mr. Brotus conveys the following to you. Your client's Mr. Tony Vermeulen conceded that PRASA is liable and responsible to pay an amount of at least 2 mil and 3 mil to Siyaya in respect of the claim which forms the subject matter of Siyaya's claim under case number 73934/25. You will recall that Mr. Vermeulen initially mentioned that an amount of approximately 5 mil is due and payable, but immediately corrected himself. His explanation in this regard was that it is a matter of interpretation. Do you recall his testimony in this regard? Question to you today is, do you recall Mr. Vermeulen's testimony in that regard?
If it's what he said, as may appear in the transcripts, I will accept that.
Commissioner Krihe excused Mr. Vermeulen to afford him and Mr. Mabunda an opportunity to meet and to verify the correct amount that is due and payable by PRASA to Siyaya. Mr. Vermeulen was keen to resolve this dispute and to do his best to liaise with Mr. Mabunda to settle this claim. My instructions are that this meeting will take place on Friday, 8 February 2017. We are eagerly awaiting the outcome of these discussions. Does your client persist in pursuing the arbitration against this backdrop? Do you see that?
I see that, yes.
And we now know that your instructions that you conveyed in that letter of 6 September 2017, which I have not seen, but I'd like to say it later, was that Mr. Vermeulen must not engage with Mr. Mabunda.
No, I think I've got a different response to that. Remember,
All right.
I said to you and I said to the tribunal that we would have had to deal with each and every one of the witnesses who were at the time in the employment of PRASA. Now, much as there was a response that was prepared for Mr. Baltek, there is a response that was prepared on behalf of PRASA, in as far as Mr. Vermeulen is concerned. Now, similarly, if you wish that I assist, which perhaps I must do, because I think you would want to possibly know how PRASA dealt with it, in as far as my instructions from PRASA are concerned, there would be then communication, if you don't mind, Chair. I'll just find it. There is communication by our office. It's an email that was transmitted by Ngabeka Zimbabwe, I think the candidate attorney in my department at the time. It was sent on the 8th of September to Mr. Mackenza and similarly to the commissioners, and I see Mr. Buotes is copied, as was Kennedy and his junior, Mr. Vermeulen himself, and Shubim Kotedi. Now, the subject matter is CIR Consulting. The letter is dated the 8th. It's for the case number 73934 of 2015. Subject matter is PRASA Rail Infrastructure Rehabilitation Program Phase 2. And the parties will be CIR Consulting Engineers and PRASA. We say we act on the instructions of PRASA and also refer to the Commission's proceedings of the 31st of August 2017, to which Mr. Tony Vermeulen was served with a subpoena to attend and testify as a witness. Our paragraph 2 says Mr. Vermeulen attended the Commission on the date referred to above, at which he was requested with the assistance of Mr. Mabunda to investigate if there were payments outstanding and due to CIR, and that if so, what such outstanding amounts are. In response to the Commission's request, it is our client's instructions that, point 1, it is pleaded in its particulars of claim that CIRDB concluded a written consultancy agreement with PRASA for Phase 2 of the Rail Infrastructure Rehabilitation Program. Point 2, it is further pleaded in the particulars of claim that the contract price for the project was agreed to be in the amount of 28,819,200 rand inclusive of VAT. Under point 3, we say under this project, PRASA has to date made payments in the total amount of 30,010,000 rand, 730 rand, which payments were made on varying dates during the course of the projects and in 2014. The next point we say, in the circumstances and as far as our client's records show, PRASA has under this project overpaid CIR by an amount in the sum of 1,191,530 rands. We then conclude by saying we are instructed further that PRASA is accordingly not liable to pay CIR and that its rights in as far as the overpayment may be concerned are reserved. Now, this is a response that was
Sorry,
sanctioned.
what correspondence is that?
Sorry, Chair?
What correspondence is that?
This is a letter by our firm on the instructions of PRASA that was directed to Mr. Mabunda Makenza, and Mr. Makenza Mabunda is the representative of SIAYA.
Do we have it? Where do we find it?
It's a group of letters that I spoke about yesterday, which I promised the tribunal I will find. I just did not know how to introduce and this is why I asked for Mr. Malika's permission, that I then deal with the letters. I've made copies, 2 extra sets.
But it makes it difficult for us to follow your evidence. You're just reading there and
You would recall, Chair,
documents which we do not have.
you would recall, Chair, that the tribunal dealt with the 417-418 inquiry yesterday. I was taken through a lot of questions, but I kept on saying there is correspondence that exists because it emanated from our firm on the instructions of PRASA, which correspondence dealt with the aftermath of the hearings themselves. I would have 4 letters which were at the behest of the commission in as far as the PRASA witnesses were concerned, because there was an attempt to have the witnesses engage further with the representatives of SIAYA in order that they then agree or not agree on whether there was anything payable or not.
My understanding is that those letters are not before us at the moment. Am I correct?
I have not found them in any of the records.
Yes. And the letters suggest what the stance of PRASA was at the time when you wrote those letters.
Correct, Chair.
So if it should be suggested, as these Mr. Boertus's report suggests, that PRASA was indebted to the SIAYA group of companies, that was not your understanding at the time when you wrote, or somebody in your firm wrote the correspondence you refer to now.
That is indeed so, Chair.
Yes. Thank you. I think it's best we have a look at these letters if we don't have them.
Yes, Chair. I think it might be useful for
Yes.
us.
Yes, no, I understand.
I see that it's 10:51. I can use fruitfully the time between now and tea adjournment
Yes.
to explore these things, but I'll be guided by your convenience, Chair.
No, I would, well, we're about 5 or 10 minutes away from this morning adjournment.
Yes.
If you should require these letters for further cross-examination of the witness, then we best give it to you now, and it would help us follow as well.
Thank you, Chair.
Yes, I think then we will, if it's possible, we'll take the adjournment now and reconvene at 11:15, if that's correct.
Thank you, Chair.
Yes, thank you.
Thank
In
you,
the
Chair.
meantime, could the witness please provide these letters, Mr. Mukhashla, to the rest of those of us who are present that you found this morning?
I shall do so, Chair.
Yes,
Thank you.
Thank you. We will then stand adjourned until 11:15.
Thank you, Chair.
Mr. Malek, are you ready to go?
Chair, thank you very much.
I just want to remind the witness that he's still under oath. Yes.
Thank you, Chair.
You do know you're still under oath, so
Very
the
well
oath still
so,
applies to you.
Thank you.
Thank you. You may proceed.
Chair, we have now received the letters to which Mr. Mukhasha referred earlier on. We have made copies for all concerned, and we respectfully suggest that they should be part of volume 29. We have taken the liberty of identifying the volume at the top of each, or the top of the opening page, and subsequently paginated it from the last document. So the bundle that is now before you begins at page 104 up to page 118, and we ask that it be inserted at the end of volume 29. Mr. Mukhasha, I'll get back to these documents, but I'd like to complete my questions to you with reference to the email from Mr. Buotas to you. We were at page 77 of volume 19. And we had discussed the second and third unnumbered paragraph referring to Mr. Familian. I'd like to continue, if you don't mind. You will see that in the penultimate paragraph of page 77, Mr.
Chair, give me a second. I'm just looking for volume 19, page 77.
Again, let me make sure that. Yes, it is volume 19, page 77.
My volume 19, page 77 is not, or maybe oh yes, okay.
The file that you have before you has two volumes. The earlier part of it is volume 19.
I have it now, Chair,
Yes.
thanks.
Are you at page 77?
Correct, I am.
Look at the two last paragraphs on page 77. There, Mr. Buotas says to you, your client, Mr. Mashia Bopape, conceded under oath that PRASA is liable and responsible to pay an amount of 8 million odd rand in respect of Siyaya's claim, which forms the subject matter of the claim instituted under case number 73933/2015. Can I stop there? Do you confirm that Mr. Maisha Bopape testified?
I don't recall being present when he was testifying, so
All right.
I'm unable to respond to that.
All right. And then he continues, he furthermore confirmed that the works were executed to PRASA satisfaction. Does your client persist in pursuing the arbitration under these circumstances? Do you see that?
I see that, yes.
And I
Chair.
take it that you read that when you received the email.
You take it that I had read?
The question that Mr. Buotas posed to you, correct?
Yes, I would have taken this into consideration. Yes, yes, Chair.
And then he says, Mr. Mashia Bopape further admitted and confirmed under oath that PRASA is liable and responsible to pay at least 14 million rand to Siyaya in respect of its claim, which forms the subject matter of case number 74281/2015. You were present when this was conversed with Mr. Bopape. Mr. Buotas says to you, immediately after the inquiry, that you were present when Mr. Bopape had testified and made these concessions. Do you see that?
I see that, yes.
Would it be fair for him to have told you at that point in time, 6 September 2017, that you were present when Mr. Bopape testified?
I think it's fair for him to refer to it.
Yes.
I attended with colleagues When I say I'm not sure, I was present when he was testifying. What it means is I may have been in the surroundings, but not necessarily sitting, listening to the proceedings.
No, I understand. I'm not criticizing you,
Yeah.
please. If, I'm simply saying, just tell us whether Mr. Buotas is reflecting the correct evolution of events before the inquiry.
I understand his statement that I was present, and I don't disagree with it.
Yes. Mr. Bupape was the author of the memorandum dated 2 June 2015, Annexure POC. I take it is Annexure Particulars of Claim 18. Does your client persist in pursuing the arbitration under these circumstances? Do you see that?
I see that, yes.
Okay. And then he refers to Mr. Lucky Montana's testimony. Mr. Lucky Montana confirmed and conceded under oath that PRASA is responsible and liable to pay an amount of 17 odd million rand to Siaya in respect of its claim instituted under case number 74281/2015. Does your client persist in pursuing the arbitration under these circumstances? Do you see that?
I see that, Chair.
And I would want to, I know that you said to the chair of this tribunal that you were instructed not to represent Mr. Montana because he was an ex-employee of PRASA, correct?
Yes, our instructions did not include him.
And can I ask you this? Did you consult with Mr. Montana at any point in time in formulating PRASA's pleas and statement of defense in response to the summons and in the arbitration proceedings?
Not for purposes of pleading, no.
Yes. And then in the next paragraph, he says, Mr. Lucky Montana furthermore confirmed and conceded under oath that PRASA is liable and responsible to pay an amount of 15 odd million rand to Siaya in respect of its claim, which forms the subject matter of case number 47598/2015. The record will reflect his testimony in this regard. Does your client persist in pursuing the arbitration under these circumstances? You were asked to read the transcript of the record, and if you did, you would recall that it deals with the testimony of Mr. Montana, correct?
I agree that it may be covered in the transcript. I did not get to that part.
All right. Then he concludes with the following: with the greatest of respect, PRASA doesn't have a leg to stand on, nor does it have a valid defense in law. On its witness's own version, having regard to the benefit of doubt, the following amounts are subject to verification and confirmation, due and payable to Siaya, and then he mentions them. I take it that you have also read that part of Mr. Buota's email to you.
Correct.
And the tribunal can fairly accept that despite the questions posed to you by Mr. Buotas, you did not respond to this email.
I have come to realize that we did respond.
When did you come to realize that you did respond?
This morning when I went through the emails from my office.
You have given us the documents which are now volume 29, page 104 to 118. I have not found any response to Mr. Buota's evidence.
Correct. It was during the short break we had, and I have not managed to print it out.
Let's just clear this up. It has been suggested to you by Mr. Maluleke that you, Mr. Maleka, sorry, that you had not responded to this. What is your comment? You say you have.
Chair, we have responded to this communication.
And that response from you or somebody from your office, we don't have that. Is that correct?
It is not part of what I managed to prepare earlier on before we started with the proceedings.
But you have it with you.
I've been referred to it, and it was sent to me by email by the office.
Now, could we then deal with the question that was put to you? Please proceed.
Thank you. I mean, yesterday you said that you got the email, you did not respond. Today you say you respond. I have not seen your email. You can make it available for us in due course. But on the assumption that you responded, what did you say to him?
If you will allow me, I can go to the email right now. All right, I've got an email here that was prepared by our Miss Ngabeka Zimbebe. It shows that on the 6th of September 2017, an email was sent to Mr. Matopo, in which email Madam Seti Baza was copied, Kennedy Zazawan was copied, Francois Botes was copied, and similarly Madimpe Mokhashwa. It says, "Good day, Mr. Matopo. Kindly find you with an even dated correspondence for your attention and consideration." Now I'm going to the actual letter. Our letter is addressed to Mr. Matopo and his office. It is dated the 6th of September 2017. It is about Siaya matters against the Passenger Rail Agency. It refers to the various case numbers. It refers to the arbitration date of between the 11th and the 22nd of September 2017. It states there as well that the arbitrator is the retired judge, FDJ Brand. We refer to the above matters. Second paragraph, it is correct that informal discussions about the future conduct of the arbitration proceedings took place between our counsel. Our counsel reported the contents of the discussions to us. The next paragraph. When we did not receive formal indication from the plaintiff's attorney, our counsel advised that we address a letter to the plaintiff's attorneys to inquire as to the plaintiff's intention with regard to the future conduct of the arbitration proceedings. Pursuant to this advice, we address a letter dated 30 August 2017 to the plaintiff's attorney. And I suppose that the plaintiff's attorney in this regard will be Mr. Matopo self. Whilst we agree that the matters are not ripe for arbitration proceedings to commence and that the proceedings must be postponed, the plaintiff is responsible for the postponement and must tender the costs occasioned by the postponement. The reasons why these matters are not ripe to proceed and which are attributed to the plaintiff are set out in our letter aforesaid. Despite the evidence led at the insolvency inquiry, our client does not concede that it is liable to the plaintiff in the matters which are subject of the arbitration proceedings. The next line, we trust that the above is in good order and hope to hear from you soon. That is the letter. Thank you, sir.
Yeah. Mr. Mokhashwa, I have not seen that letter, but from what you have read, that letter does not deal with the substantive matters that Mr. Botes has put to you and invited you to comment on. Correct?
When you say substantive, Chair, I'm not sure. Would it be line by line? What I know is I'm being asked a question about whether this was responded to, and my answer is yes. And you may very well have come to know now that over and above what I have read, which is an instruction by our client to write as we did on the 6th, we subsequently dispatched with numerous other letters that speak equally to each and every one of the cases that Mr. Botes was referring to. And I think I did say earlier that I did not think that I owed any duty to be communicating with Mr. Botes about matters we are both on record on, and more so because he had an attorney with whom constantly I would liaise regarding these matters? My answer is we have responded. It may not be that there is a packaged response that line by line perhaps deals with his email.
I will leave this issue on this basis, that Mr. Bottas testified and indicated to the tribunal that you did not respond to this email. That is version. The tribunal will make a decision on which version should be preferred. But I will take up the issue in argument. And I respectfully suggest to you that the letter that you've read to us is not a response to this email. But I'll move on.
I accept that.
By the way, the transcript of the proceedings in volume 16.1 at page 278, when Mr. Pupape was testifying, indicate that you were present, and you can have a look at it, but it does indicate that you were there when Mr. Pupape testified. And Mr. Tsawanu was there, present, also speaking on some of the matters that were raised in regard to that evidence. And Mr. Tsawanu records that he was with you at that point in time. Do you take issue with the correctness of what is recorded there?
I don't take issue with it.
We can be quick with the correspondence that you have given us this morning, now at volume 21, page 104. '29. Judge Mushidi is the small one that we have just handed this morning. Yes. If you look at page 104 to 106, deals with your instructions with reference to the testimony and the undertaking made by Mr. Baltek at the inquiry. Correct?
Correct. I've got the bundle here in front of me.
And all I wish to confirm with you is page 106, paragraph 4.
I'm on it, Chair.
And you say, consequently, it is to our client neither clear nor certain why Mr. Baltek has been subpoenaed to come and be of assistance to the Commission in the liquidation proceedings of CIR Consulting Engineerings when the GSM-R project has no links with this company in which is the subject of the current liquidation proceedings. Do you see that?
Yes, I do.
And I take it that what you said there is based on the instructions given to you by Ms. Mukotedi and Mr. Dingizoya.
That is indeed so, Chair.
Yes. And in 5, you say, in the circumstances, we request that you, alternatively the Commission, assist our clients further by responding to the submissions made in paragraphs supra. Do you see that?
I see that, Chair.
And I take it that that too is also part of the instructions given to you by Ms. Mukotedi and Mr. Diginzoya.
That is indeed so, Chair.
Yes. But as far as you're concerned, when you attended the inquiry, the 417 inquiry, you were aware of what Mr. Buota said about the purpose of that inquiry. I read it out to you yesterday.
Yes, I'm aware about what the purpose of the inquiry was.
The next page is page 107. Up to page 109. It deals with Mr. Kubue and your instructions with reference to Mr. Kubue, correct?
Correct.
And again, in page 109, paragraph 4, you say the following: it is accordingly our client's understanding of the process to be that you need to first be in compliance with these aforesaid requirements before Mr. Kubue can start engaging further on this matter. Do you see that?
I see that, yes.
And I assume that that too was part of your instructions from Mr. Dingizoyo and Ms. Mukotedi.
Correct.
Okay. Then the next page is page 10, 110 to 112. And that deals with your instructions relating to the testimony and undertaking made by Mr. Famelian at the 417 inquiry, correct?
Correct.
And for now, please go to page 112, paragraph 4. We are instructed further that PRASA is accordingly not liable to pay Siaya, and that its rights as far as the overpayment may be concerned are reserved. You see that?
I see that.
Again, that's an instructions to you by Mr. Dingizoyo and Ms. Mukotedi.
Correct.
And the last one is page 114.
114 or 113?
It deals with the question of postponement and not the evidence of the witnesses who testified at the 417 inquiry.
Are you on page 114, Chair?
Yes,
A letter addressed to Mr. Matopo?
indeed.
Oh, yes. I think, yes, this is not necessarily related to the other letters you've taken me through.
Yes. I don't know why it is in the bundle, but I just want to confirm with you that it has nothing to do with the 417 evidence.
Correct, yes.
And the last one is page 116 to 118. It deals with the attendance of Mr. Baltek at the inquiry. You'll see that at page 117, paragraph 2. Do you see that?
I see that, Chair.
And you say there, Mr. Baltek, in respect of whom we also act, attended the commission on the aforesaid date and was requested to investigate if there were payments outstanding and due to Siaya in respect of Gauteng 1 resignaling project, and if so, what such outstanding amounts are. And then you conclude in paragraph 3, we confirm that our clients are still investigating this matter and will, as soon as possible, make available to you the findings of such investigation. Do you see that?
I see that.
I take it that as far as you are concerned, you did not go back to Mr. Mackenza about the investigation that you referred to in this letter?
I don't have any personal recollection about that.
No, I understand, but your instructions are that PRASA will investigate and come back to Mr. Mackenza.
Correct, yes.
And I suggest to you that nothing was done in order to implement that instruction, as far as you know.
As far as I
Yes.
know, yes, yes, I accept that.
I'm going to jump around if you don't mind. I'd like to ask you to go to the first report you prepared for PRASA. And we now know that that report is in volume 8. And it begins at page 233.
I'm on it, Chair.
You sent it to both Mr. Dingizwayo and Ms. Mukotedi, who were responsible for giving you instructions. And it is dated 21 November 2017. You'll see all of that at page 233. And you deal with the various case numbers. You give the status report on the pleadings in the High Court and also reference to arbitration. You pick up the issue of arbitration at page 245 from paragraph 3. Do you see that?
Paragraph 3, yes, I see that, Chair.
And then you deal with the question of arbitration until somewhere at page 246, paragraph 314. Unless you have anything to say or remark, I would like to begin with paragraph 315 on page 246.
Would you wish that I quickly look at 311 to 314?
Yes, if you want to.
That's fine, thank you. Yes, I've gone through them, Chair. Thank you.
Thank you. The first time you report on the 417 inquiry is from paragraph 3.1.5. Do you see that?
I see that, yes.
And then you deal with your correspondence with CI attorneys on the 417 inquiry at paragraph 3.1.6. Do you see that?
I see that, yes.
And in paragraph 3.1.7, you confirm that we nevertheless attended the inquiry on the days that Ms. Litsani Rotaba, Soren Baltek, Tony Vermeulen, and Mr. Johan Edwards were called on to testify. See that?
I see that, yes.
I suppose your report omits to mention that you were present when Mr. Bupape testified.
As far as the record shows, yes, it seems so.
And your report does also not deal with the testimony of Mr. Montana at the 417 inquiry, correct?
I don't recall that we were present when he testified. I stand to be corrected.
But you're aware that he's one of the witnesses who was called to testify?
I personally saw him there, so yes, I'm aware.
Yes. And it does also not deal with the evidence of Mr. or Dr. Mtimkulu, who was also one of the witnesses who testified.
I met him there as well, but
Yes.
I was not present when he was testifying.
Fair enough. And I see that in this report, you do not refer at all to the email of 6 September 2017 from Mr. Botes.
I accept that.
Yes. You then prepared the second report, which is at page 266.
I'm on page 266, Chair.
And you did confirm that you prepared this report after you had read the memorandum of the chairperson of November 2017.
Yes, Chair, correct.
And that memorandum, Chair, it is from page 248 of volume 8. And for now, I would like you to go to paragraph 8.
Would it be paragraph 8 of my report?
No, of the chairperson's memo at page 250.
Yes, I'm on it, Chair.
And there you'll see that the chair says, should the contents of the commissioner's report be correct, it is clear that the witnesses made major concessions with regard to liability of PRASA in the civil actions launched by Siyaya Consulting Engineer, now in liquidation. However, despite these concessions, Mukhashwa Diale appears still to want to proceed with arbitration proceedings. They, however, did not address the prospects of success at the arbitration proceedings in view of the evidence that has already been laid in the liquidation inquiry. Can I stop there?
Yes, Chair.
Do you accept that your report of 21 November 2017 that we have looked at did not deal at all with the question of the prospects of success?
I accept that.
Mr. Fanny Dingizwayo was here and asked the tribunal to look at that report and imply that somewhere, somehow, that report deals with the question of prospect of success. He went so far as to suggest that any lawyer properly applying his or her craft will read into that report prospect of success. You accept that that's not what you did in that report. You did not address the prospect of success at all.
We don't deal with that as a subject,
Yes.
Chair.
And I take it that nowhere in the course of your preparation for the trial, when the matter was still in the High Court, and nowhere in the course of your preparation when the matter was referred to arbitration, did you deal with an advice on evidence for PRASA?
I agree with that statement. Perhaps to the extent that no report of such nature is before us. If it is something I'm required to go investigate, I'll be happy to do so.
Yes, I understand. All he did was to rely on instructions given to you by Ms. Mokotedi and Mr. Dingizwayo.
Yes, during the consultations, yes.
Much was made about the question of interests following upon the instructions to you by Mr. Zide to settle the arbitration claims. And I'd like to take you to the letter which caused a matter of concern to both Ms. Ngoye and Mr. Dingizwayo. If you don't mind, can you go back to volume 8?
Yes, Chair.
The letter of settlement, as we know, is at page 272. It goes on to table the instructions until 274. You have read it. I'm not going to take you through its terms, depending on your answer to my question later on. And I'll tell you when the question comes in. Simply identify in the documentation for your appreciation.
Yes, Chair.
If you go to page 276,
I'm on it, Chair.
that's the letter dated 18 December 2017. It's a response by Matopo attorneys to you on the instructions you received and conveyed to them. What caused some concern was paragraph 3 on page 277 of that response. It says the following: your client, PRASA, did not, in bold, instruct you to submit an offer or tender to our clients in respect of capital amounts only. Your client-specific and express instructions to you was to submit an offer or tender to our clients which provides for payment of interest a tempori mori at the rate of 9% per annum calculated from the dates upon which the respective summonses were served. Do you see that?
I see that, Chair.
Some Machiavellian outcome was sought to be drawn from this paragraph by Mr. Dingizwayo and Ms. Ngoye. What I'd like you to help us with is that it was part and parcel of your instructions not only to tender and offer settlement of the capital amount, but also payment of the interest, correct?
You lost me when you said Machiavellian.
Improper motive.
Okay. Okay. What is the question, Chair? Sorry for the distraction.
That's fine. You were instructed, as and when you conveyed your instructions to Matopo attorneys, not only to settle the question of the capital amount claimed, but also the interest flowing from that capital amount from the date of summons to date of payment, correct?
Correct.
Yes. But what you did or did not do is not to include an offer on the interest.
Correct.
In the Zondo Commission of Inquiry, you were asked questions around that issue, and you admitted that it was some mistake on your part to think the verb you used was that it was inadvertent on your part. Remember that?
Correct.
Yes. There's nothing sinister about it as far as your instructions goes and how you carry them out.
About your question is whether there is anything sinister about having omitted to include interest. Is that,
Yes.
is that what I must respond to? Nothing sinister about me having omitted the interests.
No, I'm saying that one can't read much into the fact that in your initial offer you did not include interest when your instructions were to include it.
Correct. Nothing sinister about that.
And just to make sure that the record reflects correctly what I had put to you, can you go to I think it's volume 11A. at page 190, that's where the discussion about the question of interest at the Zondo Commission begins. It begins at 190, opposite line 20. Do you see that?
I think I'm lost again, Chair. Would it be 190 of the second part?
Of volume, yeah, of the second part, the transcript.
All right. Because my 190, volume 19.
No, no,
Unless if I've got the-
11 capital A.
Oh, okay. Maybe this one. Okay, thank you, thank you. I'm on the page, Chair.
You will see that the question of interest, as far as it was discussed before the Zondo Commission, begins at page 190. Do you see that?
I see that, Chair.
And the discussion is long. It ultimately lands at page 207 of volume 11A. And the chairperson raises the issue from line 1 on page 207. And in line 10, you say, in response to the chairperson's question, the offer did not at all deal with interest, and I think it was just inadvertent on my part. Do you see that?
I see that, Chair.
Shorthand for a mistake on your part.
Correct.
The last issue which I would like to deal with, and we dealt with early on, right from the beginning of the questions that I put to you, but it occurs to me that I failed to deal with one aspect flowing from our discussion of that issue yesterday. Relates to the meeting of 8 March 2018. And you identified for us who attended that meeting. And what I want to explore with you is at that meeting, well, let me start here. When that meeting happened, you had already prepared reports to, amongst others, Mr. Dingiswayo and Ms. Mukotedi about the status of the matters, correct?
Yes, in as far as the reports of November are concerned, correct?
Yes, about the litigation.
Correct,
Yes.
Chair.
And were you asked at that meeting to give further information which was part and parcel of your files to Mr. Dingiswayo or Ms. Mukotedi or Mr. Zide or Mr. Bupape? Is it Mr. Bupape?
No, Mr. Mulepo.
Mr. Mulepo, my apologies. who were senior executives of PRASA present at that meeting?
I think I was asked to be brief about what had occurred between the period first or thereabout of December up to and including the March events, when I got a call from Mr. Dingizwayo about what he had had were applications against PRASA. So I gave an account of what happened in December, in February, and in March.
Yes. And that account, I take it, it was verbal at that meeting?
It was verbal. I didn't submit any report at that meeting.
Yes. Now, when did you close your files in these matters?
Soon after the meeting of the 8th.
Can you give us a timeline that the tribunal can work with?
I read somewhere where I said we filed a notice of withdrawal as attorneys of record on the 8th, I think soon after the meeting.
Soon after, was it matter of days or weeks or months?
Soon after the meeting of the 8th, we went on to file notices of withdrawal as attorneys of record in respect of the 4 matters. You would recall that I was instructed to proceed with the matter that was due for the upcoming arbitration hearing at the time.
I understand, but yes. What I want to find out from you is, now that you were withdrawn, did you assist the attorneys who took over, that is, Bowman?
I assisted them only to the extent that I was required to prepare bundles and to have them delivered to their offices.
And I take it that you would have made contents of your file available to them?
Correct.
Yes. Do you recall that the contents of the files you would have made available to them included your email exchanges with Mr. Botas?
It would have been everything. It would have been everything that was contained in our files.
Yes. I have spoken to Judge Makhubele about the documentation that you presented to us this morning, which is now part of volume 29, page 104 to 118. And she has asked me to put it and place it on record for your comment that in the course of the reports that you gave to her, in the course of the meetings that you had with her, you have not made available these documents to her.
I agree with that.
Chair, can I confer with my colleagues to make sure that I have not omitted anything? Thank you. Just one thing. The instructions you got to settle did not suggest that you settle every claim that CIA had instituted against PRASA at that point in time. There is one matter which was not settled, correct?
That's correct.
And in regard to that matter, Matopa attorneys proposed that it should proceed to arbitration before Judge Brand, and the dates for that arbitration had been indicated somewhere to be in March 2018.
That is correct.
Yes. And you would recall that the reason for not settling that matter was that PRASA wanted to do further investigation in relation to that matter.
That is correct.
Thank you, Chair. That will be the end of our questions.
May I just correct something, Chair, if you don't mind? The question before your last about whether I had made available these letters in the reports that I prepared or not. May I be referred to the second report of November? I'm not sure which volume now.
It's volume 8.
Volume 8.
It begins at page 266.
266. Thank you, Chair. I just want to verify something about that question. If you look at page 270, paragraph 3.12, I make reference to some annexures J, K, L, and M. And the paragraph reads, to this end, and insofar as the Commission had instructed that PRASA employees should make submissions in respect of the inquiry itself, we were instructed to, in respect of each of the matters that our clients gave evidence on, to file responses as appears in annexures J, K, L, and M. Now, although this report doesn't contain annexures it refers to, I think the annexures would be the 4 letters we went through today.
Yes, we have seen that. Are you suggesting that those annexures would have been conveyed to the chairperson?
The annexures would have formed part of the report when this report was submitted
Yes.
to the legal division.
That's fine. I have put my instructions to you with reference to whether Judge Makhubele was given those annexures or not.
Correct.
And my instructions are, you yourself did not give them to her.
I accept that. I just had to refer to this report.
No, I understand.
To the extent that it may be referenced in these letters. I accept what your instructions
Yes.
are.
I accept that you may have included them in this report in the expectation that they should be made available to Judge Makhubele. But
Correct.
the point is that they did not.
I accept that.
Thank you, Chair.
Thank you, Mr. Malika. I see we have 5 minutes to go before 1 o'clock. There's re-examination. Do you want us to stand down, Ms. Zungu? We can start after lunch.
Chairperson, it is requested that we start after lunch, please.
We certainly will. Well, we will stand down and come back at 2 o'clock for re-examination. Yes, thank you. Mzungu, you about to re-examine. Just to remind the witness, you are still under oath.
Thank you, Chair.
Yes.
Thank you, Chairperson. I have gone through the cross-examination, and I believe there's no need to re-examine the witness in this matter. Thank you. Yeah, thank you.
Yes, thank you.
Maybe if I can just place on record, there was a document that was requested for with regards to the response to Advocate Botha's email. We have been placed in possession of the documents, and we wish to place it into volume 29 as page 119, 120. It's a 3-page document and 121. Thank you, Chair.
Have you given a copy of the document to Advocate Maleka?
Yes, Chair, we received a copy.
Yes. Let me just find out if there's any further questions for the witness. Do you have any further questions, Mr. Maleka?
No, Chair.
Thank you.
Mr. Mkhashwa, I see in the bundles that we received this morning, on page 112 of the letter of the 8th of September, as well as the one that we have just been finished with, dated 6 September 2017, on paragraph 5, you kept on insisting that your client does not concede liability to the plaintiff in these matters. When did it change?
Chair, is it in as far as our firm is concerned?
Yes. When did you get the instructions to change?
I suppose you mean when was I instructed on the
Yes.
intended settlements?
Yes, yeah.
It was on the 15th of December 2017.
So all along from 2015 up until December 2017, the view was that PRASA is not liable for anything towards Siaya.
That is indeed so, Chair.
Okay, thank you.
Well, that begs the question, who gave you the instructions, and do you know why it changed?
On the 15th of December, I was given the instructions by then Chairperson, Judge Makhubele, and I believe it may have had to do with the report of or the interim report of the commission in terms of section 417 and 418.
And when was that report given?
You mean to me, Chair, or?
Yes. No, did you ever see that report?
I saw it for the first time yesterday.
Sorry, I can't.
I saw it for the first time yesterday, Chair.
But this letter is written the 6th of September 2017. Was that the view PRASA held as of that date?
Which letter, just for
The
purposes
one
of...
that we were handed in just a moment ago, page 119. It's dated 6 September 2017, paragraph 5, that was read to you.
Correct, it was PRASA's view at that time, yes, that it is
And-
not liable.
And then it changed on the 15th.
I was given instructions to settle on the 15th.
And that instructions came from Judge Makhubele. Is that correct?
That's correct.
Perhaps this is an awkward question? And if it is, please say so. What brought about the change? Do you know?
I don't know. I think
No, don't guess. Either you know or you don't know.
I don't know what brought about the change.
Yes,
Thanks, Chair.
thank you.
Mr. Mahasha, it's Judge Moshidi here. I just need to clarify some aspects of your report for the sake of
Thank you, Chair.
Could I start with your report dated the 21st of November 2017? That is in volume 8, page 233. Volume 8, page 233.
I'm on it, Chair.
In this report, like the other one as well, you set out extensively the history of these matters of Siaya.
Correct, Chair.
You even tell us what occurred during the pleadings, a request for particulars, exceptions were taken, summary judgment was applied for, opposed, and refused. You set out everything very well. You agree with me, it is, on the face of it, a very extensive report on all these matters.
I agree with
and
you.
what transpired in them.
I agree with
From
you,
the
Chair.
time when you received the summons and what happened right up to arbitration stage. Are you with me? I'm just confirming.
I'm with you, Chair, and I agree.
Well, let me start then. Bearing that in mind, let me start then with paragraph 1.3 of your report on the first page.
I'm on it, Chair.
I mean, why do you say there? Kindly be advised that this report is only intended for the purposes as indicated in paragraph 1.2 here above, and in no way constitutes an opinion for the purposes of advising PRASA on how to best proceed in defending these matters.
We had,
Is
we,
that not contradictory in a way? You set out the report extensively, but then you say no.
I can try to explain myself, Chair, if I may. We received a request that we prepare a report on the status of all of the CIA matters our firm was defending. We had very limited time periods within which to do it. It is about 5 or 6 matters that we have had to report on in that space of time. This is just to say that it goes as far as what we were able to share with clients, given our understanding of the instruction.
The thinking in this paragraph I've just read out to you, would that have led to the confidentiality clauses in the various settlement agreements? Because in those agreements, we've gone through the evidence there. The last paragraphs of the settlement agreements or offers contain a clause that is confidential. Are these two linked? The thinking behind paragraph 1.3 on the first page of your report and the clause in the settlement offer agreement.
The inclusion of that clause was on the instructions from PRASA.
Of which clause? In the settlement?
The inclusion of the confidentiality clause in the settlement offers that were extended to this group of companies. It was a specific instruction from PRASA that the offers I make include that provision. I'm not sure if I understand the question well, but that is my response, Chair.
Well, still based on, or having in mind what I said about the report, with all your experience and what you have set out in the report, consistently, you've been handling these matters at Prasa long before Judge Makhubele came there, is it not?
That is correct, Chair.
And you appear to have been consistent too in defending these matters.
That is correct, Chair.
You actually complained that the plaintiffs are delaying at some stage.
That is correct, Chair.
But now, at the end of all of this, why settle now? That's more maybe related to the previous question by my colleague here. In this report, you are consistently defending these matters. But now you come and change and suddenly you settle.
I was instructed by PRASA to settle the
PRASA.
matters, and I asked that we would execute the instructions upon receipt of written instructions.
Who at Prasa, if I may ask, gave you instructions?
I was given the instructions by the
Sorry?
then I was given instructions by the then chairperson, Judge Makhubele,
To now settle.
to now settle, yes.
So, as a professional person, from then onwards, you were doing what you did not agree with, or not consistent with your previous conduct?
I'm an attorney, Chair. I take instructions from clients. I would obviously try to assist wherever I can to guide processes. These matters are between CIA and PRASA. I'm just an agent of PRASA. If PRASA tells me that it has reasons to want to settle some of them as it happened, I was that agent who had to execute such of their instructions.
Well, instructions are instructions, we all know, but sometimes you get instructions that are not consistent.
It's not out of the ordinary,
Viable.
Chair.
Huh?
Oh, you were still carrying on. Sorry to interrupt.
I don't understand that.
Now, you were going to deal with the last issue that was put to you.
Well, I thought I had interrupted Judge Mushidi.
Yes, no, I understand. That's what I'm saying. He's finished. And do you understand what is...
May I ask that the question be asked again?
You may certainly. Judge Mashidi, put the question again.
I say we know that instructions are instructions. You're the attorney, the professional person, but there comes a time that you get instructions which makes no sense at all. Do you still nevertheless go on with those? Or is that the reason why you withdrew? It's a tenure record.
Our firm withdrew for different reasons, Chair. And I agreed with the guidance from the PRASA department, legal department at the time, that we be replaced by someone else for purposes of executing the then instruction to oppose the applications to make the awards orders of court. But I think to your question, it's not out of the ordinary that lawyers give advice and clients sometimes go against such advice.
And how were these instructions given to you? In writing or orally or in a meeting?
We were in a meeting where they were given orally. I asked that they put the instructions in writing, which they did, which PRASA did, because I received a letter on the 15th of December 2017, confirming the instructions I was supposed to act on.
I want to move to something else.
Is that letter amongst the many bundles that we've received yet? Have you seen that letter?
It has been referred to many, many times, Chair.
Oh.
Yes, it's part of the bundles.
And who has written that letter? Can you just remind me?
It was signed off by the then acting CEO, Limdekaya Zide.
Oh, yeah.
Yes. Thank you.
Thank you.
Well, let me move on to something else, and that is about the inquiry, section 417 and 418. You were at the inquiry, is that correct?
I attended the sessions, correct?
With senior counsel?
Yes, I was in the company of the appointed senior counsel, Mr. Kennedy Tsawani. And I think we had a junior, Ms. Mawande
And
Seti.
at the inquiry, you were representing PRASA?
We attended on PRASA's instructions, correct?
Sorry?
We attended on PRASA's instructions, Chair, correct?
You also attended on behalf of certain employees of PRASA. Some of them were still working for PRASA, some had left already, is that not correct?
That is correct, Chair, in as
A
far
person
as...
like Dr. Timkulu had left already, for instance.
Yeah, so the PRASA's instructions were not to be present when those who were no longer in the employ of PRASA were giving evidence. We participated in those proceedings only in as far as the PRASA employees at the time were called upon to give evidence at the hearings. So someone like Lucky Montana, we were not present when he testified. Mr. Mtimkulu, we were not present when he testified. And there could be others, I'm just not sure.
And those witnesses who were at the inquiry, represented by you, did you consult with them before the inquiry?
We did not
After
consult.
they received the subpoenas and...
We did not consult with them, and I think it was partly because we wrote to the commissioners and inquired if there were areas they would wish that the subpoenaed persons assist with. And the response we got was they don't need to bring any paperwork. All what would then happen is they will be presented with the relevant paperwork at the hearings, and they will be taken through such paperwork. So, but for the fact that we understand what the inquiries are meant for, there was not much for us to consult with the witnesses on before the hearings themselves.
If you had not consulted with them before their evidence, you wouldn't have known what their versions would be. Is it true?
That is quite indeed so. We had no idea what questions would be presented to them. And as a result, we would not have been in a situation to take a view on what they are likely or not to say at the hearings.
So you were not surprised when they made the concessions, those who did? Mr. Lucky Montana, Mr. Kobu, and I mean, they confirmed in their evidence that the contracts were there, the money was owed, the scope of the work, and some of them admitted that CIA had complied with all the terms and conditions of the contract and CIA must be paid. Were you surprised when they said that?
We had instructions to engage with them further post the hearings. We were instructed by PRASA to engage with the witnesses further, amongst others, on what they had testified about. And then it gave rise to the communication I referred the tribunal to, which I handed over this morning, as was shared amongst the colleagues and the various representatives, which information dealt with what PRASA made of their participation in the proceedings.
Thank you, Chairman.
Sorry to take you back, Mr. Mukhashwa. In paragraph 1.2 of this letter 21, February 2017.
Which page number, Chair?
Page 233, volume 8.
Oh, okay, I'm on it, Chair.
Yes, you write there saying the purpose of this report is to provide client with an update on the background of CIA summons. Our office has been instructed to defend the status of the files as well as the prospects of success. Prospects of PRASA successfully defending these matters. I think Advocate Malika has tried to solicit why did you not indicate the prospects of success, and I'm also interested.
You would recall that when I responded to Advocate Maleka's questions around that, I conceded that the report does not particularly deal with the issue as a topic. But if you look at the report, and I think as Judge Mushidi says, the report reports on the defenses that PRASA propagated for in the pleas that were filed, alternatively in the statements of defense that were filed in subsequent pleadings. And as a topic, this report does not deal with that. But the report does point out the defenses as we were instructed or had been instructed on.
In looking at each and every of these cases that you are reporting on, you indicate what is expected of the defendants to do. In fact, the plaintiffs to do. Have they done what they were supposed to do?
Chair, are you referring to this very same
letter? Yes, the same letter.
Would you be kind to give me an example of the paragraph that deals with your question?
For instance, if there was something that they were supposed to do in terms of rectifying, correcting something from their papers, the particulars of claim which were viewed by Mr. Dingiswayo as, I don't want to use the terms that he had used. Have they rectified those? Would you have seen the prospects of success? We want to be clear on this issue of the prospects of success, on could it have been the reason that led Advocate or Judge Maluleke to give instructions to settle?
I think your question, yes, has many elements to it. And I think I can simply assist by saying the following.
Please do.
The liquidators and the other company that was not under liquidation would have every reason to want to pursue their matters to finality. We got off the brief in March of 2018. We understand that there were applications after applications. If I'm correct, PRASA went on to have the settlement successfully rescinded, which places back onto the shoulders of the liquidators and CIA to pursue the matters further. And I'm not sure I can deal with questions that center precisely on an opportunity they have to get the orders they had sought at the time from either the arbitration processes or from the courts. So it is difficult for me to be referred to whether PRASA had prospects or not when we had outlined what their defenses were, not only in the pleadings, but in the letters of September of 2017, which positions we articulated to the representative of CI herself. As a firm of attorneys instructed to defend these matters, that is as far as we can take it.
Okay, thank you, Mr. Makasho.
Mr. Maleka, do you have anything further?
No questions, Chair.
Yes. Mzungu, do you have anything further?
No questions, Chair.
Well, in that case, thank you very much. I think you are further excused unless you hear from us if we require anything further.
I'm happy I can start interacting with colleagues freely now.
Yeah.
Thank you.
Yes.
Thank you, Chair. If the Chair will remember, they have one witness that is still under cross-examination, that is Advocate Buertes, and we postponed that he continue with the cross-examination tomorrow. But at this stage, Chairperson, I will not be calling any other further witness in this matter. Thank you.
So the only matter then that's still outstanding is the cross-examination of Mr. Buertes tomorrow,
That is correct, Chairperson.
as far as the evidence leaders are concerned.
As far as the evidence leaders are concerned, that's it.
Yes, thank you. Well, we will then have to adjourn till 10 o'clock tomorrow and hope Mr. Buertes is here. Thank you.
Thank you, Chair.